Now, I think we're all back. I'm sorry if that was a rather mean break, but better than nothing. Well, off we go.
My Lord, yes, I think it's probably appropriate to ask you to look at our skeleton in relation to this, because it is the point at which I wanted to return, having not really covered the skeleton outline so far, back to what we say there. And we were looking at paragraph 16 onwards, which deals with reversionary evidence. And at 17, we deal with market value. And I've made a number of the points already that are set out there, but the first point is the important one, that the only evidence before the court, tangible evidence as to what the value of the reversionary interest is on a market basis in this case, is the evidence of Mr. Watson. And for all the limitations of that market, as I observed earlier, both Mr. Dakin and Mr. Watson consider it to be an adequate market for arriving at a valuation, primarily because that's based on the yield. And the point I made before the short adjournment just now was that yield takes into account all of the risks and costs which an investor is going to factor into any purchase of reversionary interest. And of course the calculation then employs the discount rate in the table which was provided by Mr. Dakin. It's the table 28 multiplier for a period of years certain, and that takes into account the discount rate effect on the life expectancy, and that's how we get a different price. It might be worth just looking at Mr. Dakin's table, really, to illustrate this. I think we put it at the start of this report in the Expert Witness Bundles File 1. And Mr. Dakin is at tab 4. We can see from that table,
I'm sorry, I managed to lose my paper version, and I am just finding it on screen, which shouldn't take me long. Sorry to keep you waiting. I'm sorry, I'm beeping you. Right. I do now have it. Yes, thank you.
Thank you. So, my Lord, the table, of course, deals with both this case, in relation to which this is Mr. Watson's evidence as the market valuation, and then he sets out the position Mr. Dakin does in relation to the various paradigms. Now, those paradigms involve different property values. So paradigm 1, 500,000, paradigm 2, 600,000, and then the last paradigm, 250,000, and also different life expectancies. So we have 30 years, 29.2 years, and then our only example really of a short life case, 7 years. And if we look at the short life case first, we can see that on a property value of 250,000, on the market yield, which Mr. Watson has given evidence as to what he would expect, we can see that we get a rounded value of the reversionary interest of 160,000 on a £250,000 purchase. And that, of course, is a factor of the very short life expectancy in that case. So in a sense, that produces what might well be, in a case of that sort, a very large gap if that was being made at the basis of the deduction. But of course, it, as a market value, at least produces the potential for that gap to be bridged by a sale of the reversionary interest, which was the point I think I was making at the outset. And the court doesn't have to decide that that is the approach, but the calculation itself, effectively substituting the 6.6 for any other discount rate, is easy to apply in practice. But the important point here is that on the evidence before the court, it is tied to a real expectation of yield, which an investor would bring to a reversionary interest purchase. And indeed, as we discussed before the shorter adjournment, it is a figure which could be developed and honed as a market develops. And we can see, if we look up the page...
So, and again, forgive me, that would produce, as you say, a very large shortfall, yes. But quite possibly in circumstances in which there was no chance whatever of the full 250,000 being met from other items in the pool.
Yes. Well, that's
so you really are dependent on being able to, what we call the general Robertson-Johnson problem, be very acute on this methodology.
Yes, but of course it's zero at the moment. So, and the advantage we're identifying is that this is producing, as you would expect, a greater value for the reversionary interest as the life expectancy reduces. And I started by making the concession that in short life expectancy cases, it would be unpalatable to simply say, well, for a very short period of time, the defendant has to pay the full value. And that is one of the problems which is addressed within Roberts and Johnston imperfectly as such. But the position we're at the moment in Roberts and Johnston is that the result is zero. The position, if one is adopting very low values, the 1% and 2% values, the 2% value is really effectively an analogue for where we were before the discount rate changes, you can see that the gap is absolutely enormous. And that's the way in which it was going prior to the discount rate change. So it's an improvement on zero. As a matter of law, zero is the wrong result in any event because it's not compensation. This is an approach to loss which does taper according to life expectancy, and there is some obvious justice in that. But the point we really are making in terms of this being a pragmatic solution is that because this is tied to a market valuation, there is at least the possibility in a case of this sort that one could go to the market and obtain it. On Mr. Watson's evidence, if you adopt a value of 2%, then no investor is going to buy at that, and you still end up with a very substantial gap. The same.
As you say, sorry, this is just me again, just thinking now in the context of a real example. With a life expectancy of 7 years, it is likely to be more obviously attractive to a purchaser than the kind of very long life expectancy we might be considering in the present case.
Yes.
So the chance of plugging the gap may appear more realistic.
Yes, because the event on which the reversion turns, as it were, in terms of reversion to the remainder man is less distant.
Okay. All very obvious points, I'm sure, but it's just me feeling my way through them. Thank you.
And I think if we go up the page, I won't labour the point, but you can see how that works out in relation to paradigm 2, where we have a much longer life expectancy on a £600,000 property, and indeed in relation to Paradigm 1 on a £500,000 property. And in fact, as we get into longer life expectancy, we can see, as we would expect, that the gap narrows, and indeed at the market valuation, by the time we get to a £500,000 property, the reversionary interest has shrunk to 73,500, and we're well into the territory of where Roberts and Johnston was originally operating when the court regarded it as an appropriate methodology, the potential at least to try and bridge the gap, because someone who has a life expectancy of which produces a multiplier of for 30 years is also likely to have other damages calculated on a lump sum basis, loss of earnings and so on, which are going to be proportionately greater. And then finally, the valuation in this case, and this is really the only evidence of evaluation, because the fair and reasonable valuations, both in Mr. Watson's report and in Mr. Robinson's report, are simply illustrations. We haven't got a fair and reasonable valuation of this case in either of those reports. And we can see in the case of the appellant, Charlotte Swift, that the value of the reversionary interest is 49,000, with the life interest at 851,000. And again, that is an entirely reasonable market expectation, because here, although the amount of the value of the property, or the part of the property, is very large, 900,000, in which there is going to be a reversionary interest, it is delayed by many years. Hence why 49,000 on a yield of 6.6 is what one might expect an investor to pay, and that might be a very good investment in the London property market, not least if all of the predictions which were made by Miss Angel and also by the economists are right. 3.2% growth in house price inflation, 3.1% in the general inflation. But the point is that it's not the claimant who's being required to take the risk around that. It's the market. It's the investor who's taking that risk. The externalities of this problem have not been visited on the claimant, and nor should they be, because the claimant is the victim and the defendant is the tortfeasor. And the prudence adjustments that we see being made by the Lord Chancellor in setting the discount rate are appropriate to inform what the court does in this situation as well. It would be quite wrong, we would submit, to make the claimant take those risks.
Mr. Sweeting, I'm sorry to break in one more question, just to understand the way you put this. Just taking this case as the example.
Yes.
The sale of the reversion, if it happened, would be entirely down to the claimant. The mechanism would be that the damages award would be 851k, reflecting the value, or reflecting the market value arrived at by applying the percentage. Whether or not the claimant sold or dealt with the gap through other damages is up to her.
Exactly, yes. And
there's no complication of ownership or charges or whatever.
No, and there would be no question with this methodology of the court having to hear evidence about that either, of the claimant having to say, well, I've gone and got estimates for the value of the reversionary interest and so on. The evidence would proceed from here henceforth on the basis that before this court it was a 6.6% yield, because my lady observed earlier, if a market developed, it would be open to parties to come back and say that needed to be revisited, or at least potentially. That is the position. And I could hardly say otherwise, having referred your lordships and ladyship to all those references in Wales to things not being set in stone and being immutable, because that isn't a pragmatic approach to this area of law. Your lordship is, if I may say so, entirely right, because the reality is we would be squarely back, in this case, in the territory in which Roberts and Johnston originally operated, which is that deduction is well within the amount which has been awarded for general damages.
Yeah, but that's easy in this case.
It is.
Because in the hard case, much more like Paradigm 3, we obviously don't know what the amount of the shell damages was, but there might well not be such that they could be funded in that way. What might not be paradigm 3 might be any. You could easily construct a case where that wasn't so.
Oh, my lord, you could easily construct such a case, and I think...
And you just say that's rough, but there's been a rough justice. It's not very bad in your case. If it's worse in other people's cases,
well,
that's the price you pay for a workable system.
Yes, I think we accept that at the extremities, if you're going to depart from full capital value, and I've acknowledged that in the short life case where you might need full capital value to make the purchase, it is equally more likely to be unpalatable for reasons that need to be elaborated to make the defendant pay the full capital cost for a very short period of time. The reality is, the experience at the bar is I think in cases like that, one would instantly think about rental straight away if that was the possibility, or certainly in many cases, because they're settled, an arrangement whereby the defendant does purchase the property. So those things are all possibilities in that case, but we're not talking about negotiated settlements here. We're talking about how one has a workable system. The particular advantage we've identified is that if you tie this to market value, it does at least give the possibility that in that short life case, where the gap is going to be 160,000, that, as your lordship said, a willing investor could be found, because that's an investment which is going to produce a return on the face of it within 7 years, subject to the risks around life. And of course, those risks are built in to the discount rate which is being used, and the other risks are built into the yield. So, my lord, we do accept there's no perfect solution. In practice, of course, even the concept that you use unallocated damages to fund the gap is potentially objectionable. I mean, certainly in JR, for example, where PIBA were first intervening, we were saying that one of the things we were intending to argue in the Court of Appeal was perhaps the sensible deduction is simply to take off the general damages. If the implicit assumption in Roberts was that you had to use those general damages, let's turn that into an express assumption as well. And I confess that that was not for the purpose of suggesting that that was an appropriate way of dealing with it, but to actually allow the court to say that it was inappropriate to do that. And PIBA's position was it's completely unethical. Those damages are awarded for other purposes. But of course, if you say that as a court, you then have to go on to consider how the problem is going to be dealt with if you've at once said it's not appropriate for the general damages to be used.
There is a tension between two elements in your argument, and this is not your fault, it's inherent in the situation. If you say these are all entirely self-contained silos and you should get each of them, then it's wrong in principle to rob Peter to pay Paul, but then any solution which falls short of giving you full recovery is really indefensible.
It is.
And the market value might work. If there was a market which it always worked, then that might solve the problem.
Yes.
If it doesn't, you do run that risk. And I think the problem at Roberts and Johnson is their system clearly ran that risk. They just didn't notice. Well, either they did notice and thought it didn't matter, but it's not explicitly recognised in the judgment. But anyone could have told them it, because she had paid for it all in advance, or he or she, I forget which it was in Roberts and Johnson, presumably out of interim damages, and nobody really thought where the money had come from. Is that too unfair?
Oh no, that's exactly what had happened in Roberts and Johnson.
Yes, but it almost certainly did in fact come from the damages somewhere. Then it came from the fact that Granny had left them a lot of money recently, and they happened to have it in the bank account.
From an interim payment. So, and the way this normally arises in practice is that very often, particularly in the most serious cases, there is an application for an interim payment in order to fund the purchase of a house. And indeed, there is a little line of authority in which that's happened post the decision in JR and in this case.
Yep. So,
and I'm bound to say most of the first instance judges have expressed the view that the problem would be sorted out in one way or another. But, well, that's right. And it has not been an obstacle to interim payments being awarded for the purpose of purchasing property. Although in practice, of course, if one is doing the yields and column analysis, you would have to put 0 in on the state of the law as it is. The reality is, I think most judges don't expect in the long term that that will be the result.
Very well, I'm sorry, not for the first time I rather distracted you.
No, but all right, with respect, it does actually identify the paradox in these cases that I think when Lord Justice Tomlinson said in manner that in reality the expectation was that the gap would be funded. In fact, in principle, that's wrong if that was the expectation, but in practice, it's been possible to overcome the difficulty. I mean, this is not the only area of personal injury litigation in which there is a difference. I mean, one of the obvious points is that until the discount rate changed, the assumptions about the investments that the claimant would make were wholly illusory because there simply wasn't enough recovery to allow investments in the ultra-safe investments in order to produce the sums, which is one of the reasons why it changed in due course. And indeed, those investments weren't available anyway, as a matter of course. So, well, just going back to the skeleton, I won't be very much longer with this. Under paragraph 17, I was looking at the market value of the reversionary interest. I think 17.4, we make the point that fair and reasonable is descriptive in the business context for obvious reasons, but we question whether it's apposite in relation to claimant tortfeasor. I think a point I've already made. Lord, over the page at 17.5, we do actually put forward a hybrid solution. And I think I would say at this stage that on reflection, and I think probably from the outset, we think it might be very difficult for the court to order this. But it is an interesting hybrid in terms of the discussion around solutions, which is to say that if the defendant is to have the benefit of the deduction based upon a valuation of the reversionary interest, then it should be on the basis that the defendant is prepared to purchase the reversionary interest. And, my lord, that might be a solution which, in effect, generated a market, an internal market of its own, in relation to the purchase of reversionary interest, where the sale was necessary to bridge the gap. I'm bound to say that, in fact, on the way the evidence developed and the questioning of Mr. Watson around this, it looks as if that market might well be in place in any event, and it would be a much better market if it was the real market in which he already operates. So that hybrid solution, I would respectfully suggest, is an interesting observation. It would be, in our submission, a very suitable solution, but we accept that it's probably not one that the court would be in a position to order as a result of the outcome of this case. Can I go on to
Speaking, I'm sorry to bring in again, but if the defendants over time, particularly experienced insurers, felt that the market rate was too low, then at least in theory it would be possible for insurers, perhaps through a subsidiary, to test that proposition by saying, well, these are being sold at too low a rate, so we'll buy them.
Lord, precisely. I think it echoes the point I was making earlier about the fact that this has been an area of the law where effectively it's been sterile, because one might have expected lots of innovation and inventiveness to get around the problem of gaps in compensation, but there has simply been no incentive to do so. And I think, with respect to what your lordship is saying, is that in this situation there would in fact be an incentive to do it, and frankly that would be a good thing, because it might produce a better calibrated compensation in case to case, which was fairer to both parties. But at the moment it is an interesting observation in the whole area that this has limped on as a problem from year to year and has only got worse, and then of course has become disastrously so for claimants with the change to a negative discount rate. So all of the innovation one might have expected has been absent. Lord, I was going to turn to paragraph 18 and fair and reasonable, and we make a number of points which I I think can be dealt with very quickly in relation to that. Firstly, a point I've already made, really, that there's no evidence of evaluation of fair and reasonable in this case. Now, neither Mr. Watson or Mr. Robinson do that. They simply provide illustrations. And if valuations are based on rental yields, which is the case, certainly in relation to one of them entirely, then there's no evidence in relation to rental yields that your lordships could rely on. And of course, there is also, it's implicit in what Mr. Robinson was saying, the necessity to rely on very long-term assumptions. I say contrary to the economist's caveat, there are differences between the economists, but it's that necessity to make assumptions about, in particular, the inflation in house prices. Now, you will remember that we say that that's not a legitimate thing to introduce into a damages calculation anyway, because inflation is taken account of in the discount rate. But for the reasons I've developed, making the claimant take that risk, any methodology which makes the claimant take that risk is objectionable, and anything which avoids the claimant having to bear the risk of those externalities is to be preferred. And the last point, I think almost unnecessary to do anything other than say it can be illustrated from that table we've looked at that you are going to have deductions which could not be bridged if you are moving away from market value, which we would say is the effect of fair and reasonable if any further movement is made in the assessment, even if it could be on the evidence. And indeed, that is a point that PIBA make as well, they having adduced the evidence from Mr. Watson, that if it's not market value, there are going to be more cases in which the gap is unbridgeable and unaffordable. As far as Mr. Robinson is concerned, we make a number of observations at 18.2. Again, we suggest that they're all valid post the evidence, and just as they were before the evidence, no market valuation. His expertise is, we suggest, somewhat limited, and in particular, he doesn't have any expertise in the market valuation. So Mr. Watson is left alone in giving that evidence, but that's not surprising. And indeed, it's not the case that the parties, at least one of the parties here, has adduced selective evidence from only one valuer in relation to markets. Everyone has agreed that Mr. Watson is effectively the gatekeeper for the only market that operates, a point which is made for him and against him in various ways, given that it's a very small market. And Mr. Robinson's fair and reasonable valuations or illustrations are again dependent upon all the variables. He says, for example, that if he'd calculated in the way that, or addressed the issue that Miss Angel had, he would have reached the same result. And he reaches a rather bizarre result in relation to the reversionary interest, which would be identified in gold bars, which can't really have any life interest at all, apart from the cost of perhaps securing them and insuring them. So, Lord, we say his evidence really doesn't get us very far in providing any alternative, other than suggesting that it comes with all these many deficits and problems. He does, of course, adopt the approach to borrowing from other heads of damages. I don't need to repeat our observations here as to why that's both objectionable, and indeed it's likely to make the problem worse, not resolve it, and is not really open to the respondent to run argument or as a way of calculating the reversionary interest. Well, I got to paragraph 19, which I see are our final summary of submissions. So we do say that the starting point is that if the contest is between no compensation at all and full compensation for the cost of purchasing a house, the result is inevitable given the central principle underpinning damages. But we have managed to identify in the course of this case a practical and viable solution, and that is to use the reversionary interest valuation based upon the evidence as to market value. That evidence comes from Mr. Watson. We can see in operation that it would be simple to operate, that it would offer a range of solutions in many cases, and if it is indeed tied to a true market value, even if that market is a small one at the moment, there is a possibility that it will develop, and that if it does develop, it would in fact allow claimants, irrespective of anything that the court does, to be able to go into a marketplace and bridge the gap which is produced by the discount effectively represented by a reversionary interest. In any event, Roberts and Johnston simply cannot continue to be the methodology which applies, because it produces zero compensation. And unless the court was persuaded that by some sleight of hand, this is a claimant who has suffered no loss, even though she has had to fund £900,000 herself of the purchase of accommodation, then there is a loss which is uncompensated. And the role of the courts is that of making sure that compensation, insofar as money can achieve it, is full compensation. So all those are our submissions, unless there's anything I can assist you on further.
Well, speaking for myself, the questions I wanted to ask, I asked as we went through. I don't know if my lady.
No, thank you very much.
There's only one thing I thought to mention, and forgive me, I should have the authority at my mind, but it isn't. Roberts and Johnston was decided in an era when the impecuniosity of a claimant could not be taken into account. But that is no longer the law. And I don't know whether that is something that we should be considering at all in this, but I'd rather raise it while you're there, Mr. Sweeting, than...
Yes, well, we do deal with this in our written submissions, and obviously I've not gone over all of the background material and so on that we've dealt with. It's in reference to the Liabiity case, isn't it?
Well, Nicola and O'Connor was the case in which the police boss was...
It was revisited, yes.
Revisited, departed from it.
Yes.
Impecuniosity, the law is what it is, but given the way Roberts and Johnston was argued, you could hardly say that they had, they were guided by these Bosch principles. We haven't checked, but I don't think it featured in the argument at all, did it?
Roberts and Johnston is very sparse in terms of anything that it says about why the court came to the conclusion it did.
No, well, I mean, that's right. I mean, we could, I suppose, go back to George and Philip, but I think the same would be true there. So, this may be why you haven't chosen to take us to it.
13, 12, wasn't it?
That's an argument. So I think it might be difficult to say that either of the courts of appeal explicitly relied on what I might call the Liabiity principle. The most you could say it was inherent in their thinking.
Yeah.
Yes, I mean, we certainly rely on it as a change in the legal landscape, which removes one of the potential impediments to arguments about why Roberts and Johnston is inviolate. But Lord, I don't really think it...
Yeah, you've got a more direct route to that result, which is the one that you made in your oral submissions.
Yes.
Work, of course, but that I can see why you think that's easier.
Yeah.
Or at any rate, more focused.
Yes, I mean, we have made the point that one of the things which has been pursued in cross-examination is, well, in reality, this appellant has actually bought the property without borrowing. And in fact, for the purpose of an earlier application in the case in relation to protected costs orders, there was actually some evidence about the position, but the only assumption the court can and should make is that that has been funded out of damages. So it's not it's no answer, of course, to say that if a claimant has other sources of income and they are put into the property and that doesn't represent a loss, that would draw a completely nonsensical distinction between those who are injured with means and those who are impecunious. So and in any event, even those with means have had to deploy their 900,000 in a way which they would not otherwise have had to do as if they had not been injured. So these are rather circular arguments in terms of the way in which funds are introduced to purchase property.
That's true, though. In such a case, the Robertson-Johnson approach is most defensible, because there the real loss is that they could have spent the money on something else, got a return on it.
Yes, that's right. And undoubtedly, that's going to be one of the few examples of a case in which you could say it comes closer to actually identifying the real loss to the claimant.
Sorry, I raised the point. I think that's all we need to say on it.
No, I think Mr. Arney reminds me that there is a point about deductions for pre-existing borrowing costs. I suspect it might be sensible, with the court's permission, if I come back to that, if it's raised once that element is deployed. You'll find it's in Mr. Allen's skeleton as well.
I will be frank with you and say I haven't focused on it. It is an appeal by. It's a part of your appeal.
It's not a part of our appeal.
Oh, I see. I'm so sorry.
The list of that we handed up.
It was one of the solutions that was said not to be viable. Then,
no, I think it was. So it was in the summary of headline issues. It was, does the claimant have to give credit for saved but for property costs?
Well, just remind me, I'm sure my lord and my lady are completely on top of it. Remind me how this arises. If it were part of your appeal, that would give you a hard time. I don't quite see why you couldn't deal with it now unless you want to rest on your skeleton.
Well, let me just, I think
understood what the point is or how it arises.
The way in which it arose is that it was raised in the PIBA skeleton as a generic point, and then it was picked up and adopted by the respondent. So if I can just find where it is in the...
If that is right, it doesn't relate to any ground of appeal.
No, it doesn't. So.
And then I would have thought that your proposal was a sensible one.
Yes. I mean, I've certainly argued this point before, so I just think it may be sensible for your lordships to hear that point and decide whether it's something on which you want me to argue, not least because I think Mr. Allen accepts that it probably doesn't in fact arise on the facts of this case, and if it's said to be something which needs to be factored into a general solution, then it might be sensible for your lordships and ladyship to hear that first, and I can deal with it.
Practical course of this, unless my lord and my lady disagree. I haven't thought about this point at all. I think over the adjournment I will just make sure I understand how it arises, and we will then make sure that if we want it dealt with, it is dealt with in the correct order, but I can't at the moment say what the correct order is.
Certainly.
But I'm not saying we'll rise this minute, but I think there'll be an opportunity tomorrow to deal with it if it has to be dealt with. Right. So if my lord and my lady haven't got anything else, thank you very much, Mr. Sweeting. Now, I was just checking the order. I had it in my mind, but I haven't actually seen that Mr. Allen had half an hour of oral submissions. Is that right?
I think that's the position, yes. We agreed he would come next.
we've had some breaks, so we should still be fresh. On the other hand, before I decide to make him, make his submissions or start them this afternoon, it might be a good idea to get some feel for how comfortable we are for timing tomorrow. Mr. Allen, you are indeed expected to be only half an hour, since that's all you've got. If you're answering, you're muted. If you're not answering, please do. Well, we'll come back to Mr. Allen in a moment. Should someone check? I would hate to think he'd be missing the whole hearing.
He's in the list of icons, but not the microphone on.
Where's the link? You go on,
Mr. Whitehall,
My Lord,
Mr. Allen?
Mr. Allen's just dropped out of the call just for a moment. He's trying to rejoin now.
Oh, I see. Well, bad timing. Let's just speak to Mr. Ordland. Mr. Sweeting has been commendably succinct. You don't have to be obliged to match him, but realistically, how long do you think your submissions will be tomorrow?
3 hours, my Lord.
So if that is as reliable as council submissions ever is, and I don't mean that rudely, it's just a fact of life. If we heard from Mr. Allen tomorrow, there would still be time for a reply. Mr. Allen, are you now with us?
I am, my lord.
Where it really, we'll obviously make the decision. If you want to express a preference between starting now and probably only having a quarter of an hour or so, or starting tomorrow.
My preference would be to start tomorrow because one, it's then one complete run, and second of all, having heard what Mr. Sweeting has to say, it may be that I can trim observations I was going to make, he having already covered them in the interest of the comedy.
That's the inducement council always offer. Well, unless my lord, my lady, feel desperate, feel cheated at rising at 4:05, I think we will do that. We will sit tomorrow at 10:30. We will hear from you, Mr. Allen, for no more than 10:30, for half an hour. And if you're right, maybe slightly less. And that still gives plenty of time for Mr. Ordland and a reply, even if it takes you slightly longer than you thought.
Yes.
Very well. We'll sit tomorrow. Thank you.
Thank you.